Dear students, welcome to Learn to Live. In this video, we'll be discussing about offer. The term offer is derived from the Latin word offere, which means present or provide. The word proposal is used in the Indian Contract Act in the same sense as the word offer is used in English law. Section 2, Clause B of the Contract Act provides that when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes promise. Section 2, Clause C of the Contract Act says that the person making the proposal is called promisor and the person accepting the proposal is called the promisee. Promisor is also known as offerer or proposer. Likewise, promisee is also known as offeree or proposee. Essentials of a valid offer. 1. An offer must be intended to give rise to legal consequences. The offer arises from intention. Intention is not defined in the Contract Act. However, in Section 2, Clause A of the Act uses the word willingness, which is equal to intention. A case related to this is Rose and Frank Company versus Crompton and Brothers Limited. 2. An offer must be one capable of creating legal relationship between two parties. A valid offer must intend to create legal relations. If this offer is not intended to create legal relationship, it is not an offer in the eyes of law. A case related to this is Balfour versus Balfour. 3. The terms and conditions of an offer must be definite, unambiguous, and certain. According to Section 29 of the Contract Act, agreements, the meaning of which is not certain or capable of being made certain, are void. The case related to this is Gutton versus Lynn. 4. Offer may be specific or general. Offer must be addressed. When offer is made to a specific or an ascertained person, it is known as a specific offer. When offer is made to public at large, it is known as general offer. In specific offer, the acceptance from the side of offeree is sufficient to form a binding contract, while in general offer, the acceptance can be made by any person. The case related to this is Carlyle vs. Carbolic Smoke Bowl Company. 5. Offer must be communicated to the offeree. An offer is effective only when it is communicated to the offeree. Communication is necessary whether the offer is specific or general. According to Section 4 of the Contract Act 1872, the communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. The case related to this is Fitch versus Snedeker. 6. Offer is different from invitation to offer or quotation. Invitation to offer is not an offer. Where a party, without expressing his final willingness, proposes certain terms on which he is willing to negotiate, he does not make an offer, but he only invites the other party to make an offer. It is called invitation to offer. Students, this is the end of the section. Please share, like, comment, and subscribe. Make sure you press the bell icon for latest updates.